back on the record in cases. First case is cause number 326-198. Second case is cause number 327-044. Both cases are styled the state of Texas versus Cynthia A. Proctor. We have Ms. Proctor, who's present in court, and Ms. Proctor is also present in court with her attorney, Mr. Ryan Matuska. And we also have present the State Assistant District Attorney, Mrs. Ashley Ramos, and we also have present, sitting second chair, State Assistant District Attorney, Mr. Ray Shearer. Mr. Matuska, are you ready?
Yes, sir.
Mrs. Ramos, are you ready?
Yes, Your Honor.
Okay, Mrs. Ramos, you may proceed. I think when
Yes, Your Honor.
when we went into recess, you had put a offer on the record. Could you repeat that offer?
Yes, Your
If you don't
Honor.
mind.
Actually, I'm going to adjust the offer because as I had spoke to Mr. Matuska, I made an adjustment in our offer.
Oh.
So the current offer is 90 days over 1 year probation, a $400 fine, 80 hours community service, the DWI education course, drug and alcohol assessment. And if he agrees to forfeit the weapon, we'll do a dismiss and please in the DWI case, and we will do a dismissal on cause number 327044.
Okay, Ms. Proctor, do you accept or reject the state's offer?
I'm so sorry, and I appreciate it, but I reject.
You reject offer? Okay, all right, and that should be noted on the record. Okay, you're welcome. Now, Ms. Ramos, do you have anything else that you need to?
Yes, Your Honor, the state filed the state's first motion in limine, and I served Mr. Matuska, I also gave Mr. Matuska a copy of it, and I believe that Mr. Matuska also filed this. motion.
Yes. I have a state's motion, it's the state's first motion of limity, which has been was filed on April the 13th, 2021. Mr. Matuska, have you had an opportunity to receive the state's motion for limine?
Yes, sir.
You have any objections?
Yes, sir.
Okay. And let's do this here. Let's go paragraph by paragraph. Now, Mr. Matuska, let's see. Says now, comes now the state of Texas by and through the Assistant District Attorney Ashley Ramos prior to trial and voir dire of the jury panel and request the court to instruct Ryan Matuska and through him, the defendant, Sylvia A. Proctor, and all defendant's witnesses that they not refer either directly or indirectly nor allude to in any fashion without first having taken the matter up with the court outside the presence of the jury the following, okay? Number one, specific acts of misconduct or criminal record of the state's witnesses unless counsel for the defendant can show that such acts or offenses have resulted in a prior final conviction, a prior final felony conviction, or a prior final conviction for a misdemeanor involving moral turpitude, and that if such conviction exists, that it be shown not to be too remote for impeachment purposes, or that a suspended sentence has been given and has not been set aside, or such person has been placed on probation and the period of probation has not expired. And to that first paragraph, Mr. Matuska, do you object?
Your Honor, I haven't received a witness list, but I anticipated all the witnesses to be officers or technicians. So I think if that came up, Brady would be an issue right now. So I don't have an objection to that one.
Okay, and number two, any mention that the state has filed a motion in limine?
No objection to that one.
Number 3, any mention of the jury verdict and or punishment of any specific case.
I'm a little unclear on that one, Your Honor.
Okay, you need her to explain? You
Yes,
say she was unclear?
yes.
Okay.
If
Ms.
she-
Ramos?
Ms. Ramos can clarify that one.
Yes, we're just asking that you not bring up what the punishment has, or jury verdict has been in any other, case, specifically, anything like this case, where you're gonna say something like that in other DWI cases.
Well, Your Honor, I don't want to approach if an officer brings that up on voir dire. The only thing I was going to get into would be what's on the sheet.
And I don't have an objection to you during voir dire getting into, when you look and see that somebody's done prior jury service, what's allowed in a voir dire case to go through with them.
I don't foresee any problems with that one, Judge.
Okay. Number 4, any mention of a plea offer made in any specific case.
No objection, no.
Any mention by the defendant's attorney that if the defendant is granted probation and violates a term and condition of probation, the judge will revoke the probation and sentence the defendant to time in the Jefferson County Jail.
And Your Honor, on that one, I think that he is now elected for the court to assess punishment, so I don't anticipate he's gonna be bringing up punishment in, voir dire. So I'm not sure that that one's gonna matter.
Yeah, I wasn't going to talk about probation voir dire.
Okay,
And I believe there's several of these, at the time that I filed this, I wasn't sure if Mr. Matuska was going to, elect for the court to assess punishment or the jury, and so there's several that I filed that are related to punishment.
okay. Any explanation of the matters inquired about in the states? Have you heard questions as such merely test the credibility of the reputation witnesses and are not substantive evidence of the defendant's bad conduct, which may be explained by the defendant?
No objection to that one, Judge.
Any evidence of good character or alleged good character of the defendant, Cynthia A. Proctor, if such evidence is not based upon the witness having been substantially familiar with the reputation of the defendant prior to the date of this offense.
No objection to that one, Judge.
After voir dire, any reference during the guilt and innocence phase of the trial regarding the punishment range for this particular offense?
Judge, I think that is relevant for me to get into. I do object to that one.
Okay, you think it's relevant? What,
I mean,
okay,
I could perceive possibly being relevant, yes.
okay, Ms. Ramos?
I think that it's improper to talk about punishment during the guilt innocence. And if he's electing to have the judge to assess punishment, then punishment shouldn't even come up during this case.
Okay, Mr.
Judge, the jury's entitled to know this Class B misdemeanor what the punishment range is.
Yeah, but I know that's normally done during voir dire, isn't it?
Whether I'm asking about what kind of punishment they would choose is different, but just the punishment range in general.
But that, I usually tell them what the punishment range is in voir dire.
Yeah, so I don't see the issue. If you're gonna say it, that's the only, it seems very general and you're gonna tell them, so I don't see the issue.
Well, I mean, you just keep on bringing it up. I mean,
No, I didn't.
before,
I didn't perceive that.
if you're gonna do that, I'll tell you, I think the best thing to do is first approach the bench.
Okay.
Before we go
I
into
read
it.
As to be, you can't talk about it at all, ever.
Yeah, you
It
just need to,
seems-
no, you just have to approach the bench. That's what the motion and limited is. Before you go into it, you approach the bench,
Yes, sir.
and then the court makes a ruling. Okay? All right. So with reference to that, you objecting to that? Or,
Yes, for 8.
okay, well, I'll overrule that because if it is mentioned, well, before it's mentioned, the court is gonna require that you approach the bench prior.
Yes, sir.
Okay? Any, number 9, any mention of anyone's opinion as to the defendant's guilt or innocence?
Yeah, I've checked that. I would like to talk about the presumption of innocence.
Yeah, okay, Ms. Ramos?
It's more talking about, questions where you're asking the witness to say
Oh, you-
whether they think that the defendant is guilty or innocent.
A witness.
Correct.
Okay. You said any mention of any
Yes.
ones.
Anyone?
I agree that that is vague,
Okay.
but I'm.
So this just is in reference to,
Yes.
any mention of a witness's opinion as to the defendant's guilt or innocence, is that what you?
Yes, Your Honor, that's what I'm.
Okay, because he can ask the question on voir dire with
Correct.
reference to, the panel. Okay. Witnesses. Okay. Asking the prosecutor to stipulate to any fact in the presence of the jury.
No objection.
Okay. That's number 10. Where's 11?
Oh, I had taken 11 out and then I didn't do my renumber.
Oh, okay.
So the numbers are off and
Okay.
then on.
Okay. Number 12, any mention of any alleged practice of the Jefferson County District Attorney's Office in offering probation to first-time defendants?
And again, Your Honor, that was going to be one on when I was not clear on whether we were going to be doing punishment to a jury or punishment to the judge. And so that one is no longer an issue.
Okay, no, okay. Number 13, the testimony of any purported expert until the witness qualification as an expert can be determined. Oh, okay.
I don't have a problem with that.
Okay. Number 14, any evidence of the beliefs or opinions of a witness on matters of religion, if the purpose is to show that the reason of the beliefs, opinions, the witness's credibility is enhanced.
I'm a little unsure.
Okay, Ms. Ramos?
I mean, it's, if you're going to be asking, I don't know if you're intending to call any witnesses and if you're trying to use their religious beliefs to try and make them appear to be more credible, it's what that's intending.
Specific questions as to why they're more credible because they're religious?
Correct.
Okay, well, I wasn't gonna do that.
Okay. And number 15, any mention that normal use requires an inquiry into the defendant's normal physical,
Into
normal
what-
faculties or?
No, into any mention that normal use requires an inquiry into what the defendant's normal faculties are.
Okay,
Your Honor, I do anticipate normal use to come up.
that's the element.
I'm a little unsure specifically as to the inquiry into, normal use is going to be applied to the defendant.
That's true. Okay,
But it's improper to say that a witness is to know what her normal daily faculties are. And so what we're objecting, or what we're asking for in the motion of the limines is any, he mentioned that normal use requires an inquiry into knowing what her normal faculties are. And I do have, I believe I have case law on that. I had case law on that before when I filed this motion on legal.
okay, you have a case?
Can I have a moment to pull?
Yes.
Your Honor, I don't anticipate making the blanket statement that there is a test inquiry to be determined first, if that's what we're getting at.
Hold on a minute. Let me take it off. Okay, it's off of mute.
You know, just generally speaking, this normally comes up when the question may be asked of a witness, you do or do not know the normal faculties of so-and-so, the defendant. So I'm specifically, I just asking Ms. Ramos to add a little more to that.
What are you asking me to add?
Well, can you give me a scenario you were looking out for? Should I approach before?
When you're doing like a line of questioning with officer and you ask them, I've had defense attorneys who want to ask about, well, do you know, the defendant, do you know what her normal daily, normal faculties are outside of today? And that's been shown to be improper, that line of questioning. And so I'm asking that we.
Yeah, I'll make a case on that. The officer never seem to know that. I think it's relevant. If they do know, I think that's very relevant to the case.
If you're gonna deny it, okay.
I think Okay, I mean, it's, if we get to it, I mean, like we said, before it even comes up, you still have to approach the bench.
I can approach it.
Yeah, and then you can, if you have an objection, you can make your objection. And if you have, case law that, we'll be, happy to hear. You can present the court the case law that supports your position.
And all I was asking with the motion and limiting is if it's going to come up, is that we approach.
Well, that's what motion and limited basically is, that before you go into it, you approach the bench.
Well, Judge, this issue sounds like it's going to be exactly that scenario. And
Okay.
I did plan on bringing up.
I know, but what we're saying is just approach the bench. If she has an objection, she has a case on, don't her, and then the court will make a ruling.
Okay.
Okay? Now, so we'll grant state's motion and we'll note objections to 8 and 15, and the state abandoned number 12.
And number 5.
5, you abandoning that?
Yes, Your Honor.
Oh.
Because it also dealt with.
Okay, so we're abandoning 5 as well. So we're abandoning 5 and 12, and the defense is objecting to 8 and 15, but the court is granting the motion with the instruction that if counsel go into any of the paragraphs here listed, that counsel first approach the bench.
Yes, sir.
Okay. Next. You have anything else, Mrs. Ramos?
No, Your Honor.
Okay, Mr. Matuska?
Yes, sir. I have one also.
Okay. And Mrs. Ramos, have you had an opportunity to review Mr. Matuska's defendant's
Yes,
motion in limine?
yes.
And do you have any objections? Do you, should I go one at a time, or?
Well, I think we've covered 7.
Yes, we did already cover 7.
Okay,
And I have no objections to 6.
hold on.
Okay.
No objection to, no objections to 6, okay?
No objection to 5.
No objections to 5.
With regards to number 4, I had played some excerpts for Mr. Matuska on some of the video that I intended to bring in this case. And there is one that I will have to edit due to it talking about extraneous unadjudicated offenses, but I don't have an objection for just, it'll be delicate in this case because of everything going on. with
So you'll have a redacted, version of the
the-
tape,
The videos.
the video? Okay,
Yes, Your Honor.
okay.
I don't have any objections to 3,
Okay,
and just for clarification on 2, Mr. Matuska, you watched the videos that I was possibly going to admit.
Yeah, I
Do you-
didn't anticipate that that would come up, but it always goes with number 1, so I leave it in there.
Okay.
I-
And then with regards to number 1, there are going to be some statements that I intend to introduce of the defendant prior to her arrest in this case.
Judge, that's kind of the meat and potatoes of this whole thing. If we could just approach on the statements of the defendant and clarify our positions, that's,
okay, so, paragraphs 1 and 2 will be granted. And, however, well, the state would have to approach the bench prior to going into those statements. Because I guess what you're saying, there may be some res gestae statements that was,
yes, Your Honor, but Ms. Ramos has been working hard on the redaction, so it may not be.
oh,
that
okay,
much
so it
of an
may already
issue.
been redacted.
Yes, Your Honor. And I've
Okay.
already,
And you gave him a tape so he could review it?
Yes, sir.
Yes, I
Okay.
played it for him. I can get you a copy if
And
you would like.
I'll
me
look
to
over the
get a copy.
redaction tonight, Judge.
Okay. Let's see, let me go back. I thought we started at 7 and went backwards. Okay, that was the last one.
Sorry, I went backwards, Judge. Just
Okay.
noticed we hit that one.
All right,
And Judge, I haven't filed these because they're more in person, but I do have the election.
oh, I think you gotta, e-file that.
Okay. can I
Election
take it?
of, yeah, you
Can I
just
take it
need
to
to
the
get
back?
that e-file. That's a pretrial motion, right?
It is, Judge, but I bring these in person so that they can.
I know, but I think the rules are, all motions have to be e-filed. The court is not allowed to take, motions.
Same as the application.
Yes,
Well, can I at least put on the record that the defendant has chose judge for punishment?
you can do that, but they still need to be filed.
Yes, sir.
Okay, so
I'll
I'll
do
give you,
that.
I'll give you time if you need some time to go file it.
Yes, sir, but I'm gonna have to probably drive to my office to do that. You get a notary, my application.
Oh, maybe notary's here.
Yes, sir.
We're on the record in cause number 326-198. The case is styled the state of Texas versus Cynthia A. Proctor. Let the record reflect that Ms. Proctor is in court with her attorney, Mr. Ryan Matuska. We also have present the state assistant and district attorneys, Mrs. Ashley Ramos, who's sitting first chair, and Mr. Raymond Shearer, who's sitting second chair. There's been an issue that has been brought to the court's attention, and the court will address that issue. At this time, we want to ask that Ms. Linda Faye Ballou come forward. And I think we're going to have counsel to come forward, and counsels at her to come forward. Ms. Ballou, you come forward. She can stand right here because we can on this side. This yeah, Miss Ballou. The speaker on this is right here. So we just need you to stand a little off to this side. Let me do this. I'm gonna put this on mute. Back on the record in cause number 326198, case is styled the state of Texas versus Cynthia A. Proctor. My name is Judge Terrence L. Holmes. I'm the presiding judge here in this case. And good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2 of Jefferson County, Texas. You have been called for jury duty for this week. You will be examined for inclusion on a jury hearing a criminal case. Now, courtroom hours normally vary from 9 a.m. until 5 p.m. Whether or not you're selected as a juror in this case, you have to be mindful that you are performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate at recess, for lunch, or for meals, and at night. I have an administrative matter that I must attend to before administering the first of 2 oaths you will be asked to take as jurors today. Now, the first thing I need you to do, I need every one of you to raise your right hand. And then once I finish, if you agree, say, I do. You and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as jurors, so help you God. Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine whether or not you possess the qualification for service on a criminal jury trial. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. I will first ask questions, but I would ask that you hold those answers until I ask whether or not any of you or feel that you're disqualified with any of those questions. Now, if you feel that you're disqualified, what we'll do, we'll bring you up before the bench, that is before the court or before the judge, and we will ask you questions in private. You will hear this little noise, and that's so that it'll be in private and the other members of the panel will not be able to hear what is being discussed. Does everyone understand? Okay. Now, first of all, my first question is this. Except for failure to register, or you're a qualified voter in Jefferson County, Texas, under the Constitution and laws of the state of Texas. Next question. Have you ever been convicted of theft or any felony? Next. Are you under indictment or legal accusation or on deferred adjudication probation for any felony? Now, I must ask this question. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and reside in this county, Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petit juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? Now, just by show of hands, is there anyone that believes that they may be disqualified? Okay. As I survey the panel, no one's hands have been raised. So therefore, everyone on the panel is qualified. Next, now I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just please continue and remain seated. Now, I would ask each one of you and just reserve your answers. You can answer to yourself, and then when we get to the end, we'll ask whether or not you would like to claim one of those exemptions. Are you a person who is over 70 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher learning? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petit juror in the county during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of your county of residence? If any of these exemptions apply to you and you do not desire to serve as a juror, please come forward to the bench at this time and we will or we can discuss these matters. Is there anyone here who will be claiming an exemption? I take by your silence, no one will be claiming any one of the exemptions. Now we will move on to excuses. If any of you feel that there is a reason why you cannot sit as a juror today, please come up to the bench after I finish asking the questions, and we will discuss your excuse. Number one, a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the state, the district attorney's office, and the consent of the defense. And that's pursuant to the Texas Government Code, Section 62.110C. Now, if any one of you articulate an inability to listen to testimony and be fair and impartial, you may be excused. Now, if you feel there's a reason why you cannot sit as a juror today, please raise your hand, and then we will have you to come up to the bench so that we can discuss your excuse. Okay, we got two. All right. Okay. Let's do this. That's juror number 2. And there was another hand back there. Late, let's see. That's 1, 2, 3, 4, 5, 6, 7, 8, 9. Is that Miss Morrow? Is that your name, Miss Morrow?
Ms. Morrow?
Yes, okay, that's what I just was trying to find out. Okay. Step over. Okay. Oh, we gotta turn the camera around too. Okay. Back on the record in clause number 326198, cases style the state of Texas versus Cynthia A. Proctor. We have Ms. Proctor, who's present in court, with her attorney, Mr. Ryan Matuska, and we have the state assistant district attorneys, Mrs. Ashley Ramos and Mr. Raymond Shearer. Now,
Judge, mind your way. Camera?
no, the camera right here. That's, no. You, I think it's there where you can be on the camera. Yeah. Yeah, that's fine. As the court was conducting an impanelment of the jury, the court got to the portion of excuses after going over the qualifications and exemptions. And court asked whether or not if there was anyone who feel that there's a reason why they cannot sit as a juror, asked them to come forward and raise their hands. And so two people who are on the jury panel raised their hands. One person is Miss Felicia Ann Fontanet.
Correct.
Is that correct?
Correct.
Now, Mr. Fontaine, if you want to talk, since you have the face shield on, you can put the mask down if you desire to do that. If not,
Okay, I can. Okay.
okay. Now, Miss Fontaine, first of all, how are you doing?
I'm good, how are y'all?
Okay, we're doing fine. Miss Fontaine, you expressed to the court that you wanted to exercise an excuse.
Well, not per se excuse, I kind of had a question because excuse me, gentlemen, I have a well woman exam that I scheduled 4 or 5 months ago tomorrow. And I need to know if I need to call to cancel. I don't have a problem serving. It's just that because of 24-hour protocol for doctor's visits, I just wanted to make sure that, to let the court knows.
Okay. Now,
And just to clarify, I think she was saying if she doesn't let her doctors know within the 24 hours, she gets charged.
Correct.
Right.
Yeah.
okay, within the 24 hours or before the 24 hours, I'm trying to figure
It
when
would have to be, well, my 24 hours really have passed, but when I called the
That's what I was
doctor's
wondering.
office this morning, I told them that I was on jury duty, and she said to call before 4:45 today.
okay, so they gave you an extension,
Yes.
basically.
Correct.
Okay. Now, okay. State, do you have, in reference to Mrs. Fontanet's statement, I guess she's urging maybe a reasonable or sufficient excuse?
Yes, Your Honor, and I can attest that when I've had to make those appointments, you don't get them quickly. They're very difficult to get, so if she were to need to reschedule, it might be a burden upon her to have to try and reschedule that.
And, okay, so, Mr. Matuska?
Well, Judge, I don't want to be the bad guy, but it seems like we're up against the wall here on our numbers.
I understand.
But I appreciate your honesty, Ms. Is it
Fontanet.
Fontanet.
And I don't have an objection. I understand in medical issues.
Okay,
And if that's the issue, I can call the doctor's office to cancel. I just, I don't want to be, since you say you're up against it, if I had not had it, I wouldn't have raised my, like I said, I don't have a problem serving.
Mhm.
It's just that I have until 4:45 today to cancel, to try to reschedule it whenever.
Yes.
okay. So, okay, Ms. Fontanet, your excuse appears to be reasonable and sufficient under Article 35.03 Section 1 of the Texas Government Code, Texas Code of Criminal Procedure, and under the Texas Government Code, Section 62.110A. The state does not object. The defense does not object. So at this point, let's do this here. Have a seat out in the hallway,
Okay,
and then we'll come back in. We'll let you know.
okay, that's fine.
All right.
Thank you.
Okay, let's bring in the next person. Beppo, just 1 minute before you bring in the next person. I was just gonna bring in the next person anyway, because they may have another excuse that's even, more serious than hers. So I just think we just need to have both of them on the record.
Yes, sir.
But I have no objections to that.
Okay. You can bring in, Karen Louise Morrow. That's your number 9. You're number 9.
I think it just goes on the back one.
Yes, ma'am. That's right.
Chairs there.
Oh, wow.
Yeah. It was already gonna come up. You're seeing what.
Yes, ma'am.
Okay. How you doing, Mrs. Morrow? Okay, let's do this here. For the record, your name is Karen Morrow, is that correct?
That's correct.
And now, Ms. Morrow, prior to you being asked to go into the hallway with the rest of the panel, the court asked if there was any one who feel that there's a reason they cannot sit as a juror today. And you raise your hand, is that correct?
That is correct.
And you are, okay, so what is your reason?
Well, actually, I would very much like to serve on the jury.
Yeah, you can pull your mask down if you
I pull
decide.
down, okay.
Okay,
I'd very much like to serve on the jury, but this is the problem. I heard most of what you said, but when you lower your voice, it gets muffled. And so, if they're gonna, when they talk, lower their mask, I would very much like to serve on the jury. But if they're not, I'm afraid I'll miss something I should hear.
oh. Okay, let's see. Oh, okay. Now, in reference to excuses, I did state that if a jury who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. So, thus far, you're saying that you've been having problems hearing what's been said?
Yes, I have 2 hearing aids, and they're up. I turned them up to whoopee,
Okay.
and I can hear people move things around, but it's not helping with the mask. It's
Okay,
the mask that's the problem.
okay,
If I can't hear, if you're like this.
right,
And.
that makes it
when
a
you
lot
talk
harder,
loud, I heard what you said.
but,
When you dropped your voice.
okay,
So
state.
I don't know what your procedure here is. I don't know if when you talk, you bring your mask down.
Oh, well, most of the time, we usually have masks up, but, when people have shields, just like I inform you, you can take your mask down and talk as long as you have the shield. Now, Mrs. Ramos?
I think it's kind of difficult because I know we have the procedures set out by the court and for the COVID protocols.
Right,
And I'm not opposed to if I need to put on a shield and lower each time I talk, doing that. I don't know if defense also would be willing. But that would require the court to have for each witness as well, the shield for her to be able to hear, but I'm not opposed to trying to make the best accommodations that we can for her if we need to. I'm also not opposed to if, because of the COVID protocols, if we have to excuse her
Yeah,
on doing
Now,
that as well.
okay, Mr. Matuska?
No, Your Honor, she had me a whoopee.
She has one.
See, she didn't hear.
I need to hear what you just said.
Okay.
Oh, there you go.
No, but,
Yeah.
now, Miss, Morrow, the only problem is I can't guarantee that you're gonna hear everything.
Right.
I mean, because, you have
That's kind of
judge talking, you
important
have,
here.
lawyers asking questions, you have witnesses answering, so I can't guarantee that you're gonna hear it, and I do know that you had said that you had an you have 2 hearing aids, I think that's what you said.
Right, the one he's here, yeah.
Yeah, and so that is a problem. Now, I do know, as I was looking at, exemptions, and, obviously you didn't exercise an exemption, because if you would have, I mean, you can, because, of the age, but,
I'm over 70.
hmm?
I said I am over 70.
Right. So, but as far as the hearing is concerned, I can't guarantee you that you're gonna be able to hear everything. Um, just because of your condition, I know we can do all that we can, but sometimes it's difficult for us to hear sometimes, we have to tell people to talk up
Mhm.
and that type of stuff. So, but the only problem is I don't know. We wouldn't know if you are hearing or not hearing unless you prompt us and say, well, I didn't hear that. And then we would have to, I guess, ask the person who's talking to speak louder and to repeat. So that's the only,
Is the microphone gonna be on, or are
Yeah.
they just gonna talk their normal voice?
no, the microphone is, that the mic is on.
Is it on for you?
Yes, it's, I got the green light.
Yeah, that's what I was gonna say, it was on for him as well.
Yeah, that's why the green light is on. I looked over there and saw, it's right here. So that says it's on.
Yeah.
Yeah,
And I can't hear some of what you say sitting over there.
and the jurors will be sitting out there in the gallery, because that's part of our COVID protocol. So, okay, so state,
I don't have an objection.
okay,
Objection.
okay. You'll be excused. Everyone could just go have a seat outside,
Okay,
and then we'll get you to come back.
okay, thank you.
Um,
Yeah, we can.
Okay, let me, just when she gets out. Well, we won't have enough jurors to try the case.
No. And I'm not opposed to if Mr. Matuska wants to try again the next time we have a juror.
You get
available on
you talking about the
the
number 1 setting?
For a number 1 setting. So
Whatever you guys want.
I know that you've been waiting for a while.
Oh.
Actually, I haven't had the case very long, but
Okay.
whatever, I'm ready to go.
Yes,
whenever
we'll
you
do a
guys-
number 1 setting on our next, here, so we have to inform the jury. We just don't have enough.
Yeah.
Okay.
But, Judge, we tried.
Well, yeah,
So-
it didn't hurt. It didn't help when, yeah. Okay, well, okay. Okay, good afternoon, ladies and gentlemen. Again, I'd like to welcome you back into County Court at Law number 2. Ladies and gentlemen of the panel, I just brought you back in to inform you. Well, first of all, let me thank you for being here today. In a misdemeanor case, the number that's on the jury is 6. We have 6 people who sit on the jury. The state is allowed to strike 3 from the panel, and the defense is allowed to strike 3 from the panel. So that just simply means that if the state strikes 3, the defense strikes 3, that's 6 right there. So we need a minimum of 12 people on the jury after doing voir dire. And if we have 12, the state does this, strikes 3, and the defense strikes 3, that means we have 6. We have enough for a jury trial. In the misdemeanor case, felony cases is 12, but we're not there. So here, because of the pandemic, we've been having some issues with getting jurors. However, we thought that we may have had enough jurors, and we did have enough. However, once we go through the impaneling process for individuals to see who qualifies, who exempts, excuses, then we determine who is going to be voir dire. We have to have at least 12 to see whether or not we can see the jury. So unfortunately, we do not have enough to seat a jury. Okay, we don't know that ahead of time. We find out once we go through the qualifications, we go through the exemptions, we go through the excuses, and then we go through what is called voir dire. Voir dire is where they ask you questions. And then the state could strike for, we get what they call peremptory strikes, and we have what is called challenges for causes. So a person has a cause so that's, they can strike additional people besides the 3 that they normally get. So say that to say this, we don't have enough to seat 6 people. I know some of you looking around say, oh, yeah, but once we added up the numbers and looked at excuses, exemptions, and all of that, we don't have enough. So unfortunately, we won't be able to have a jury trial on this case today. And that just simply means, as far as the state and the defense, our next, we have trial dates. So our next trial date, then we'll try it again, okay? But on behalf of the citizens of Jefferson County and behalf of the staff here, County Court at Law number 2, we'd like to thank you for taking time out from your busy schedules. Because not just your busy schedules, but coming under these circumstances, we see everybody with masks and shields on. And so we like to thank you for coming down here today. And now in County Court at Law number 2, we handle misdemeanor cases. We handle Class A and Class B misdemeanor cases. And cases such as possession of marijuana, such as DWIs, thefts, burglary of vehicles, possession of a controlled substance, usually pills like Xanax. And so we handle a number of cases. The difference between the felony cases and the misdemeanors is that it's the range of punishment and the type of cases. But in a misdemeanor case, the range of punishment, we handle Class A and Class B misdemeanors. The misdemeanors are divided into Class A, B, and C. The Class C misdemeanors is what you find in the JP court, Justice of the Peace, or the traffic court, city court. It's fine only. You can't be sent to the county jail. You can be sentenced to a fine. But here, Class A and B misdemeanors, you can't be sent to the state penitentiary. However, you could be punished. Your punishment could entail county jail. You have a Class A misdemeanor, The punishment ranges anywhere from 0 days to 365 days in the county jail, or anywhere in between, or a fine from $0 to $4,000, or anywhere in between, or you could be given both such fine and confinement. For a Class B misdemeanor, the range of punishment is anywhere from 0 days to 180 days, which is 6 months, a fine from $0 to $2,000, or anywhere in between, or you could be given both such fine and confinement. Or you may qualify for probation. There are 2 types of probation. Person can get regular probation or deferred. The difference between the two, deferred probation doesn't result in a conviction on your record, and you may get what is called a non-disclosure. And however, the regular probation does result in a conviction on your record. Okay, but we look forward to trying this case. Unfortunately, we just didn't have the numbers to try the case. But I tell people here in County Court at Law Number 2, we do things a little different. We don't have court as usual, we have unusual court. And the reason why I say that is because it's not because we're different, but because we're trying to make a difference in the lives of the individuals that come before the court. And we're trying to make a difference in Jefferson County. That's why we have a program here that is called the Community Safety Initiative. That stands for, we call it the CSI program. In that program, we have partnerships with some of the agencies in the Jefferson County area. If anybody have mental health issues, we have counselors and a mental health officer in court who can do a private interview. They can do an assessment, and they can do treatment. The MHR can, and it could be outpatient, inpatient treatment. If you have an issue with drugs or alcohol, we have a partnership with Spindletop MHMR. They have an ATAR program that's called Addiction Treatment and Recovery for Youth. And there's OZAR, our local drug and alcohol council for adults. They can do screenings, interviews, and treatment plans, either outpatient, inpatient. And if you are unemployed, out of work, or have a job that you think you want a better job, we have also job training and job placement. And that comes through a partnership that we have with the Golden Triangle, Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. It stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are given training in those areas, they will assist you at getting a job in those areas. And not only that, but Spindletop as well as Lamar has a GED program. So if you need to get your GED, you can go there, they can help you get your GED. The benefit of the program, one of the benefits is it's free. Doesn't cost the county anything, don't cost you anything to get into the program. The other benefit of the program is the program can be used as community service towards your case. So if, for example, if you have to pay a fine, you cannot pay the fine, and we put you on a payment plan, but you can't pay it on the payment plan either, we can convert your fine and court costs to community service. Once it's converted to community service, any one of those, in community service, so every hour you do a community service, you'll be given $12.50 that will go towards your fine and court costs. So if you're if you have a mental health issue while you are in counseling for an hour or whatever, that 1 hour is 1 hour community service, and $12.50 goes towards your fine and court costs. The same thing for job training, your GED, your drug or alcohol treatment. And so I tell people this all the time. Not only do we have unusual court, but we also don't just arrest the problem, we address the problem. And we believe that if you address the problem, we can make Jefferson County a safer place for all of us to live, work, and go to school. Because why? Because we'll be producing productive people. Productive people normally do not commit crimes. And so this is what we're doing here in County Court at Law Number 2. We're trying to make a difference in the lives of the individuals that come before the court and make a difference in Jefferson County. We're trying to produce productive people. We are not just arresting the problem, we address the problem. That's why I say we don't have court as usual. We have unusual court. So my name is Judge Terrence L. Holmes. I'll be remiss if I didn't introduce you to our staff here. The young lady here to my left is Miss Kim Broussard. She is our court reporter. She's been typing and taking down everything that has been said, not only what I said, but also any responses. We have at the district attorney table, we have Mrs. Ashley Ramos. She's assistant district attorney. And we have, I guess we could, and also we have Mr. Raymond Shearer. I call him the dynamic duo. Why? Because we have, that's the father and that's the daughter. Okay. And so also we have one of our prominent defense attorneys, Mr. Ryan Matuska. And he is representing Miss Cynthia Proctor here in this case. Also, the gentleman that you've been seeing coming in and out of the door, the man that normally keeps law and order in the courtroom is Mr. Scott Pepple. He's our bailiff here. And I know the picture that you see on the wall is the late great Judge Lupe Flores. He was a judge here before I was. Unfortunately, in 2015, Judge Flores died. An election was held in 2016. I won the election. And that's why I've been here since actually December 2016. Judge Flores' philosophy was that county court at law number 2 will be a people's court. I have the same philosophy. I'm a judge who loves the people, by the people, and for the people. And so I tell you this, I know we're under COVID protocols, but once the pandemic is over, and it will be over, anytime you're in the area, just feel free to come and have a seat in the courtroom. I tell people this all the time. I know when you came here, you looked up over the door and you said, oh, I'm in the right place, this is Judge Holmes' court. No, this is not my court, this is your court. I'm only a public servant serving the people of Jefferson County. So anytime you're in the area, please feel free to come have a seat in your courtroom, okay? And so it's open to the public. Now when we're no longer under the COVID protocols, you can sit in that area back there. We call that the peanut gallery. But it does not mean you can bring peanuts in here and eat. But you can come in, have a seat, sit down, and see what goes on in your courtroom. So at this time, again, ladies and gentlemen, I'd like to thank you for taking time out from your busy schedules to come here today. And at this time, I'll put you in the hands of our bailiff, Mr. Scott Pepple.
Anybody can get inside their places going.